Hello, I'm Jim Turk, and I'd like to welcome you to the Center for Free Expression's virtual forum series. Today's panel is titled Corporate Rules, the Real World of Business Regulation in Canada. I'd like to begin the session by acknowledging that the land on which I am speaking to you today is the traditional territory of many nations, the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis. I'd also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the Williams Treaty signed by multiple Mississauga and Chippewa bands. I also want to thank the co-sponsors for today's panel, and they are the Edmonton Public Library, the Thunder Bay Public Library, the Milton Public Library, the Toronto Public Library, and the Vancouver Public Library. The panel is a discussion, but also today we're having a book launch for a very important new book. Randall, if you could put up the cover for it. This is a new book that's just been published, for which one of our panelists is both the editor and a contributor, and he and the other panelists all have important chapters in this book. The title is the same as the title for our panel, Corporate Rules, the Real World of Business Regulation in Canada. And we'd certainly encourage you to go to your favorite bookseller and get a copy. I think it's going to be the definitive book on regulatory capture in Canada. Canada has put serious effort into protecting the public through the regulation of corporate behavior in key sectors of our economy, such as aviation, rail and other transportation, energy, including oil, gas, and nuclear, health, banks and other financial institutions, construction, mining, the environment. In theory, the regulators are arm's length bodies acting on behalf of the public that ensure that private firms and public agencies do not act in ways that endanger people's health and safety, endanger the environment, defraud the public, harm consumers, or undermine competition in the marketplace. Unfortunately, there has long been evidence that regulators are not ensuring the protection of the public. Several decades of governments in Canada committed to deregulation have resulted in diminution of the number of regulatory bodies, decreased funding for them, a shift in emphasis from regulatory enforcement to one of encouragement and guidance, and in some cases, turning over self-management to the regulated bodies themselves. The contributors to Corporate Rules, the Real World of Business Regulation in Canada, provide a picture both of what is happening now across many regulatory sectors and the effectiveness of our key regulatory bodies. The book's comprehensive overview, moving beyond sectoral anecdotes, hopefully will cause a fundamental re-examination of the capability of governments in Canada, regardless of the party in power, to give priority to the public interest as opposed to those of the private and public entities being regulated. The format for our panel is one in which I will engage the panelists who I'm about to introduce to you in a conversation about their contribution to the book and more generally about regulation and the effectiveness of regulation in Canada for about 45 to 50 minutes. And then we'll turn to you, the audience, for any questions you may have for the panel. If you look at the bottom of your screen, you'll see a Q&A button. The chat button doesn't work for this version of Zoom, but the Q&A button does. So if at any point in our conversation, there's a question you would like to ask the entire panel or one of the panelists, just click on the Q&A button, write your question. And when we do turn to the audience, I'll turn to Ange Holmes, the coordinator of the Center for Free Expression, who will be monitoring the questions that come in, and I'll ask her to share the first question that's come in for the panel. So you'll have ample opportunity to raise your questions with the panel when we get to it, but don't wait till we get to that portion. Just feel free to ask your question as it comes to mind. So I'd like to begin the introductions of our quite remarkable panel. The editor of the book, as well as a key contributor, is Bruce Campbell. Bruce is the former executive director of the Canadian Centre for Policy Alternatives. He was awarded a Law Foundation of Ontario Community Leadership and Justice Fellowship and spent a year as a visiting professor at the University of Ottawa Faculty of Law. He's currently an adjunct professor at the York University Faculty of Environmental Studies, and he's a senior fellow here at the Center for Free Expression at Ryerson University. I guess this is the last day I can say that because Ryerson changed its name as of today to Toronto Metropolitan University. Welcome, Bruce.
Thank you, Jim. But the center remains the Center for Free Expression.
It certainly does.
Good.
Joining Bruce on the panel is Theresa McClenaghan. Theresa is the executive director of the Canadian Environmental Law Association and has been so for the past 15 years. She has a Bachelor of Laws from Western University and a Master in Constitutional Law from Osgoode Hall Law School. Before she worked for the Canadian Environmental Law Association, Theresa was a senior policy advisor to the Ontario Minister of the Environment, where she was responsible for overseeing the passage of the Clean Water Act and the implementation of the remaining Walkerton Inquiry recommendations. I don't know how many of you remember the Walkerton Inquiry, the terrible things that happened with water in Walkerton, but Theresa played a really critical role. She was co-counsel representing the concerned Walkerton citizens in both phases of the Walkerton Inquiry. She's co-author of a 3-volume annotated book entitled Ontario Water Law, and she's appeared before the Canadian Nuclear Safety Commission and the Federal Court on a number of nuclear power environmental assessment and licensing matters. Welcome, Theresa.
Thank you. Thanks, Jim.
Our third panelist is Jason McClean. Jason is an assistant professor in the Faculty of Law at the University of New Brunswick and an adjunct professor in the School of Environment and Sustainability at the University of Saskatchewan. He has a joint Bachelor of Civil Law and a Bachelor of Law from McGill. After completing that, he clerked in the Supreme Court of Canada for Madam Justice Maurice Deschamps. Much of his research focuses on environmental law, natural resource law, climate change and energy policy, and sustainability pathways and co-benefits. Prior to entering academia, Jason practiced corporate law and commercial litigation at Osler, Hoskin, and Harcourt in Toronto, and international commercial arbitration at Sherman and Sterling in New York and in Paris. Welcome, Jason.
Thanks, Jim.
And our final panelist is Jennifer Quaid. Jennifer is an associate professor and vice dean of research in the civil law section at the University of Ottawa. Her scholarly and policy work and extensive public engagement focuses on when and how law can be used to stimulate good governance and ethical business practices. Her most recent work is focused on organizational sentencing, anti-corruption enforcement, in particular the enactment of Canada's new remediation agreement regime, and the intersection of competition law and the digital economy. Welcome, Jennifer.
Thanks, Jim. Glad to be here.
Well, I'm really delighted with this panel. All of you are people whose work I've respected for a long time and was so happy to see your chapters in the new book. I'd like to begin the conversation to sort of set the stage for our discussion with Bruce. Bruce, could you tell us what led you to want to edit a book on regulation in the public interest and a little bit about the breadth of the book?
Well, Jim, you know the answer to that question because you are the guy, along with the publisher James Lorimer, who approached me and asked me if I would be interested in putting together a book like this, because it's really an extension of, because I had written the book on the Lac Megadict rail disaster, and you know, a central theme of that is the power relationship between corporations and governments, in this case between the railways and between the Transport Canada regulator, and the theme was capture and corporate capture and complicity.
Bruce,
and so
just for people in the audience who don't know about the Lac Megadict disaster, could you just describe briefly what that was?
Yeah, it was an oil train carrying 72 tank cars of very volatile back and shale oil from Newtown in North Dakota on its way to the Irving refinery in St. John, New Brunswick. And part of that line went through Lac Megadict. And it just, I could go on for the whole session to talk about it, but this particular cargo, this was a runaway train. It was parked on the top of a hill, about 11 kilometers away from Lac Megadict, and there was a fire on board, and the firemen put out the fire that disabled the brake, and eventually the air flowed out and it started to move, and 15 minutes later it derailed right in the center of the small town of Lac Megadict on the border close to Maine, and it killed 47 people. 27 kids were orphaned. 6 million liters of oil spilled. The symptoms and the conditions are still there. PTSD, environmental issues, et cetera, et cetera.
And it
was
burned down much of the
a
town.
terrible tragedy.
It burned down much of the town too, didn't it?
The center of the town was burned. Yeah, yeah.
So
it did.
was it? I assume there was some failure in regulation.
Yes, regulatory failure and corporate negligence. So the two kind of the two kind of partners in the result that happened. And I mean, they're still trying to recover from it, and we're almost 10 years after, and the government is committed to building a bypass, and it's still a mess. Its construction still hasn't gotten underway, and there's lots of rancor in the town against Canadian Pacific, because Canadian Pacific, well, that's another story.
I mean, the point is, we came to you to edit a book on regulatory capture because
that's right.
You had really looked at the issue in some detail in your fine book. I think it was published in 2018.
Yeah, and there was a French version published a year later. That's right.
That's right. That looks at that. So can you just tell us a little bit about the breadth of the book? I mean, you have a chapter about transport regulation and transport.
Yeah, I mean, first of all, I mean, I just want to thank the people who responded. I had no idea when I set out on this journey, including the people that are participating this evening. I had no idea what the response would be, and I was just kind of overwhelmed. And you mentioned some of the sections and sectors that have been analyzed. All in all, 15 chapters, 18 contributors, an introduction, a conclusion, and and your preface, Jim. Thank you very much. But it and the chapters reveal that this capture complicity relationship has infected a broad range of sectors. You can't automatically say the relationship exists across the board. I mean, there are some differences, there are variations, and there are cases where it doesn't apply so much, but in most cases it does. And
so
yeah, and I want to say
before we go into that, just tell us a little bit about what regulatory capture actually is, or an example of
the capture and complicity relationship. I mean, that's that I could spend a fair amount of time, but let me just list some of the characteristics of the relationship. So invariably, or most of the time, resources have been shredded. This happened with Transport Canada, and the government ceases to be a countervailing force like it was before the 80s, or in the 80s. The transformation happened, and sort of a deferential relationship replaces one of tension, where the leadership identifies with industry.
The leadership of the regulator, right?
Yeah, that's right. And so the industry is able to block and delay and dilute and reverse regulations that adversely affect its costs. And so effectively, it's a kind of a self-regulation. And public servants, and some of the chapters really, because there are a number of people who wrote chapters who were whistleblowers. And so they're pushed out, or public service become increasingly gun shy in the face of criticism. There's this revolving door factor, which exists in most of the sectors and was observed by most of the authors. The agenda setting takes place behind closed doors. So it's lack of transparency, lobbyists, cabinet ministers, committee chairs, and so forth. That's some of the characteristics of capture that you'll see, and I'm sure my fellow participants will verify and expand on those characteristics. Excuse me, I've got to have a okay. I'm good.
Thank you, Bruce.
Okay.
Theresa, could I turn to you? Your chapter in the book is titled Nuclear Power, Regulating the Nuclear Power Industry, the Need for Independence of the Regulator. Most people would agree that there are few industries where the impact of error, mismanagement, or disregard of safety factors could have a more devastating impact than in the nuclear industry. Something I'm painfully aware of because I live about 30 kilometers from the Pickering nuclear generating station.
Mm-hmm.
So if there is an accident there, unfortunately, it will certainly affect a large percentage of the population of Toronto and Oshawa and a huge area around it. So could you tell us about how strong are the regulations for the nuclear industry in Canada and how stringently they're enforced?
Mm-hmm. It's an interesting industry because there's no doubt, as you say, that there's a really significant need for regulation because of the hazard. And public oversight is essential, and the international conventions in this area talk about that and talk about the need for public trust and transparency and involvement of the surrounding community. But unfortunately, what we've seen from time to time in many of the accidents is that the causal factors include regulatory failure. And one of the common factors that's been singled out is hubris. So the regulator and the industry who do spend a lot of time, exchanging technical views outside of public purview for the most part, become very, very comfortable with their technology and don't admit to the possibility of, such extremely large consequence accidents. And that certainly has been true in the Canadian context. But Fukushima was a huge wake-up call because there is a Western government regulator operating on almost the same type of mandate as the Canadian and other Western regulators. And the government of Japan's inquiry pointed out that regulatory capture was one of the causal contributors to the Fukushima accident, and we see that over and over again in the nuclear sector. And it's a real world problem because it affects decisions about the stringency of requirements, about how much money to spend, about the way risk is evaluated, whether to allow aging plants like Pickering to continue to operate, which I maintain they should not be doing. In the case of Pickering, they chose not to refurbish it for cost reasons, and it should be shut down. So it's an extremely interesting set of regulations, which are very vague in many ways and up to the industry itself to oversee in many ways. And the regulator considers itself more of an auditor of the operation. And in Canada, compared to the US, for example, it's a very non-prescriptive approach to regulation.
The Center for Free Expression, one of the areas in which we do a lot of work is whistleblower protection. And we're one of the principal whistleblower support organizations in the country. And we've had whistleblowers approach us with regard to the nuclear industry, people who've worked in the industry and have expressed concern, for example, about how when a particular aging plant starts getting at the limit, the regulator will allow the allowable limit to be raised, rather than seeing the generating plant as exceeding what it should. Is that something you've seen?
Absolutely. So first of all, on the whistleblowers, yes, we too. I personally have received information from whistleblowers from time to time in this industry. I've also noticed in recent years that some former employees are beginning, some of whom were whistleblowers, and have really suffered for that, but have started to be very willing to engage in the regulatory process and be public and transparent, and also increase the capacity of civil society and the communities around what those technical issues are about. So that's very, very interesting to see. In terms of the aging decisions, yes, that happened first at Bruce, and then at Pickering, and the first time it came up in the Canadian regulatory context would have been the Gentil 2 reactor in Quebec, but Hydro-Quebec decided not to refurbish and also not to continue to run the plant beyond its original design hours. And this is something that the regulator has really considered with interventions for many of us repeatedly, and has repeatedly allowed for those excess hours to operate.
Okay. We'll come back to some of these themes, because I will want to ask you about secrecy and the public interest in that industry. So Jason, the federal government recently released a new climate plan. I think it was called the Emissions Reduction Plan, the first of a series of plans under the Net Zero Emissions Accountability Act that was passed last year. It also announced a raft of new climate policy spending measures in the budget. Do you still think the government's climate policy imagination is captured by the oil and gas industry or not?
Thanks, Jim. It's a great question. And sadly, the answer is unequivocally, yes, it is. The latest emissions, or the emissions reduction plan that you mentioned, the first plan under the recently passed act, which is designed to get us both to meet our 2030 Paris Agreement targets, but also a net zero target for 2050, is a reckless plan that isn't in alignment with climate science whatsoever. Rather, it's more like a wish list for the oil and gas industry, and I'll tell you just a couple of ways. One is, speaking of the budget commitments that you mentioned, the largest piece of spending in the recent federal budget on climate initiatives is an investment tax credit for a technology called carbon capture, utilization, and sequestration. For those of you participating today not steeped in that, what you need to know about it is that it's a technology that purports to capture emissions and sequester them deep in geological storage as part of power production. And it's a technology that's been permanently in the experimental stage for decades, despite billions of dollars of public investment, and it remains completely ineffective. And yet the largest piece of spending in the budget doubles down on investments in this technology that will serve only to prolong further oil and gas production, including Canada's equally reckless bet on what's called blue hydrogen, which is the production of hydrogen using natural gas along with carbon capture and sequestration. And just today, the Commissioner of the Environment and Sustainable Development released 5 new auditing reports. And one of those reports looks at the many gaps and loopholes in the overall patchwork and effectiveness of Canada's carbon price, and concludes that our 2030 target is in some jeopardy because the government has placed undue reliance on technologies and continued fossil fuel production, largely at the behest of the oil and gas industry. And to just give you a really pointed example about that, and in terms of what I would call exhibit A of regulatory capture in terms of Canadian climate change policy. Earlier this year in January, over 400 academic scientists, interdisciplinary researchers, myself included, who work on climate change science and climate change law and policy and economics, wrote a letter to Minister Chrystia Freeland based on scientific, peer-reviewed, independent scientific evidence, really cutting-edge brief report, urging the government not to go ahead with its planned investment tax credit for carbon capture and sequestration. And the government didn't even meet with us to discuss our concerns. Now, it's not every day in Canada that you can get 400 academics to sign their name to an evidence-based approach. You can sooner get 400 cats to walk in a straight line. And yet the government didn't even deign to meet with us. Well, why not? The government's mind was already made up, and it was made up by the oil and gas industry. So unfortunately, Jim, neither the spending commitments in the budget nor Canada's latest emissions reduction plan show any evidence that the government is inclined to base its climate policy on climate science, and it's rather based on the talking points directly supplied by the oil and gas industry.
Do you have some sense of the ways in which the oil and gas industry has been able to be so effective in dealing with government?
Well, a variety of ways. I mean, you know, and this, you know, as Bruce mentioned in his introductory remarks, you know, this is a process that goes back decades. I mean, really even longer. The very beginning of environmental laws and natural resources laws in Canada in the 1970s were characterized by backroom agreements rather than, you know, sort of top-down regulation that people sometimes imagine when they think about government regulations. Because Canada has obtained a significant economic benefit, although not nearly the benefit that it's often made out to be in the corporate-owned media, but a benefit nevertheless. You know, the industry meets with oil and gas representatives regularly, but it's not just with oil and gas representatives. It's with our major banks as well, who continue to double down on their investments in the oil sands. So the Royal Bank of Canada came out just recently with a report talking about as if future oil demand is something that's separate and apart from the actions and the decisions that we make. Oh, we're going to need oil for decades still. There's going to be a place for Canadian oil and gas production. So when you combine the relative expertise and the economic pull that both the oil and gas industry have and the financial sector has, compared with the government's own expertise, it's really enthrall. But Jim, I would say it goes one step deeper than that and really ties to our ongoing settler colonial mentality in Canada, where we see economic innovation still as ripping and shipping natural resources, unfortunately. And so in many ways, you don't have to think about regulatory capture when it comes to climate and energy policy in Canada as something sinister. Most of our ministers and our elected officials already see the world in the same way as the oil and gas industry did. And I actually found out today that the Minister of Natural Resources, Jonathan Wilkinson, claimed in a committee hearing just recently that the government refused to meet with the 400 plus academics who have science and evidence-based concerns about an investment tax credit for carbon capture by saying that none of the 400 signatories were relevant experts in the area. And the only thing I can imagine, I know it's such a astonishingly counterfactual statement, is that his imagination of what expertise is what comes from the oil and gas industry. And so we are in a very, very dangerous situation in Canada, both in terms of our climate commitments, but also in terms of prudent economic policy making. We're really about to fall behind advanced countries who have a responsibility to lead in this regard.
Thank you, Jason. Jennifer, corporate behavior, as you've talked about and others have, can be shaped by criminal law, not just by regulation. We've been talking about regulatory capture, but is it possible for the legislative amendment process, using the law to try to regulate or to shape the behavior of corporations. It's possible for that process to be manipulated by corporate interests in a way that has analogous effects to regulatory capture.
Well, thanks for the question, Jim. There's no question that the answer is yes, although I think what I would start by saying is that we, in Canada anyway, in many sectors that are regulated, and I put that in quotation marks, there is a spectrum of responses that the regulators or the agencies that are responsible with overseeing that area of activity, and it tends to be organized by sector of economic activity, but not exclusively, that can range from, on the one end, sort of the education and discussion and, informal consultation all the way to litigation, civil litigation, regulatory litigation, and criminal litigation. And I guess for the audience that are not legal specialists, there is a subset of criminal law that is called regulatory law. And so these are criminal offenses designed to be applied in a regulatory context, and they have certain characteristics about them. The most important, I think, for people listening here is that they are structured in a way that, if you will, limits what the Crown has to prove initially in the following way. What it basically says is the Crown has to prove that whatever was prohibited or whatever should have been done was not done or did happen. Think of a environmental company that that causes chemical waste to go into a river. So the Crown needs to prove that that happened, and they need to prove that beyond a reasonable doubt. But what would normally have to also be proven is that the reason for that happening is that someone screwed up. Either they were grossly negligent or they intended to do it or something like that. And in criminal law, we don't just normally allow for simple negligence, which means you acted in a way that wasn't comparable to the prudent and reasonable person. But in regulatory law, what happens is the Crown proves that the thing happened, and then the burden shifts, and the accused has to, it's usually a company, not always, has to prove that they were prudent and diligent. And so they have to say, well, we were not negligent. And if they can do that, then they won't get convicted. If they can't do that, then they will be convicted. And that's important to mention because a lot of regulatory law contains these types of offenses that are intended to backstop, be a sort of pointy edge at the end. And because they are easier to prosecute, if you will, it's more common for criminal prosecutors to bring those kinds of charges. Parenthesis, Bruce was talking about Lac Megadict, which is something I've also written about. In that case, to the great dissatisfaction of the general public, after the trial of 3 individuals very far down the food chain, and we can talk about that later, that's characteristic of our criminal law, unfortunately, there was supposed to be a trial against the company. That was abandoned, and instead there were settlements involving regulatory offenses. And of course, part of the reason for that is that those regulatory offenses didn't require the same kind of evidence. And without the convictions of the individuals, it was going to be very difficult to bring criminal prosecutions against the companies. So I just close that. But true criminal prohibitions do exist, and they can be applied against corporations. And one area where this is particularly the case is the area of corruption, which really doesn't have a regulatory equivalent. Almost all other sectors do in some way. Even in competition law, where you have very serious offenses, you have kind of civil variations of that. Same is true in other areas like occupational health and safety, where you have a whole series of regulatory offenses, and then you could ultimately, if you wanted to, try to bring a criminal negligence prosecution. Doesn't usually work, but that, and we can talk about that later. But in corruption, you don't have a civil variation of corruption. What that means is you've got a pretty stark binary choice. So you prosecute or you do nothing, sort of. And in that context, other countries, and the United States was the leader in this regard, and they don't just apply it to corruption, but corruption is certainly one of their core areas where they do it. They came up with a midway solution, let's say, which is called a deferred prosecution agreement. And this kind of resolution, which in the United States is entirely a function of prosecutorial discretion. So it is not overseen by courts. It is not controlled by legislation. It is an exercise of prosecutorial discretion. And they can decide to settle a case differently. And the different way they settle it is to say, we're not going to proceed with the prosecution and end up with a conviction. And I should add that in the United States, obtaining a conviction against a corporation is easy, easy, easy. It's a big difference with Canada, but that's again, we can talk about that if we want later. But the important thing is that they won't convict you, but you do essentially get subject to the equivalent of criminal sanctions. So it's sort of doing a weird inversion of the criminal process. You're sort of saying, we're not going to do the conviction part. We're just going to impose the consequences, usually financial, and then also corrective measures through a compliance order of some kind. Why is that important? Why does that matter? Why do people care? Because in corruption, the kinds of companies that get accused of corruption typically are involved in areas of the economy that involve public tendering. So engineering, services, construction, giant infrastructure projects. You also have oil companies, sometimes transportation suppliers. If you think of the big names that have come across your radar being involved in corruption, at least internationally, you can see it's quite a substantial section of the economy. So why does that matter? Because if you're convicted of corruption, most developed countries and most large international organizations will say, okay, you've been bad, you can't bid on public contracts for X period of time. So creating this resolution where you get, if you will, the outcomes instead of but without the conviction, is a way to sort of cut the apple in half, or cut the pear in half, as we say in French. This is a significant sort of tool. Canada never used this tool, and prosecutors in this country did not feel comfortable. And I have to say the defense side also didn't feel comfortable with doing it the way the Americans had, with sort of letting it evolve as a part of prosecutorial discretion. They wanted to have court oversight. So we looked to the UK for inspiration in that regard. But how did that conversation start? And this is the part, sorry, it's a very long answer. This is the part where you come into the capture problem. And that is that when did Canada finally decide we need to start thinking seriously about deferred prosecution agreements? The UK did it in 2014, but other countries have done it early. The Americans have been doing it since the early 90s, they've been doing it since the 60s and further, but really since the early 90s in a sort of significant way. Well, it's funny. There were these charges laid against this large company. And then there was a change of government. And literally, this is the thing that was the most interesting about, and why I wanted to write this article with my co-author, by the way, Steve Biddle, who is not here, but was a very, very important part of this article. You draw the timeline of how things happened. So how did we get from the kernel of an idea that maybe a deferred prosecution agreement type thing should happen in Canada to the enactment of it? And you overlay that next to the progress of the prosecution against SNC-Lavalin. And there is a curious lack of, or I should say a curious presence of alignment at key moments. And so what that causes you to do is to start thinking about, well, so how did that happen? Well, as it turns out, the beginning of the process is a closed door Chatham House rules meeting under the auspices of a think tank, where a variety of people were invited, but many of these people are from a particular segment of society and represent particular interests. And they produce a report, which doesn't attribute, it's Chatham House rules, it comes under the auspices of a think tank. But from there, essentially, if you look at what ultimately happened in the DPA regime, that is the template. And what happened afterwards were a series of steps that were designed to make it look like the government had considered other views, but really you can almost draw a straight line between that. So this is an example of where, the capture process, if you want to call it, but where, interests that are not really the public interest. And, I'm not judging SNC-Lavalin necessarily in the sense of saying, of course they're motivated. Why wouldn't they be, right? And of course they would like this tool to be available, but the government's position should be more critical and should be taking a stand. So indeed, you want people to come with their strong views, and you want a collision of those views, and that is what didn't happen. Mm-hmm. And that is why we have the regime we have.
You mentioned one thing that certainly I found interesting, and you might for our audience, when you said, well, getting a conviction against a corporation is easy in the United States, but it's not so in Canada. Could you just tell us a little bit about why that is?
It's actually pretty simple. In the United States, they apply a standard of liability in criminal cases at the federal level. Some states are different, but let's say at the federal level, which is what matters for the FCPA, for the antitrust, a ton of, and other big federal legislation. They apply a standard called respondeat superior, which basically means that the corporation is answerable for every single person associated with it. And so you can have any level of employee, and so long as you can pin the criminal act on that person, you don't have to worry about, who they are, or, what their level is. Yes, it has to be done in the scope of their employment, but, American authors and are pretty much across the board say that there is really no debate. If you can find one person who committed the crime, you've got the corporation. This gives it a leverage to the deferred prosecution negotiation that is entirely different to what happens in Canada, where we for now anyway, this is what we have. The Westray law, created this regime, which is an improvement over what was there before, but is still different. Essentially, you have to find other people. And when you're talking about a crime that's like corruption, where you have an intentional component, so it's not enough to say you were negligent, you have to have had an intention. In some way, somebody who qualifies as a senior officer had to have an intention. I won't get into the details, but at the end of the day, the regime very much focuses towards finding an individual. And that actually matters in the deferred prosecution agreement scenario. And that's one of the things that I think wasn't thought about very seriously, is that corporations are expected to cough up individuals in that process. But one of the reasons why they want that process and they want it to be overseen is because if you cough up the individuals, you're essentially handing over the evidence that could convict you. So that's a dynamic at play there. But that's why it's so much easier in the US. For them, it's all about sentencing. The prosecutors know they've got the corporation. The discussion is all about, okay, what are you going to pay?
So in Canada, having a lower level employee who's responsible for this isn't necessarily enough to capture the corporation.
No, it's never enough. Even for negligence crimes, the senior officers have to have the negligence part, the mens rea, if you will,
Right.
part has to come from the senior officers, either a single one or jointly. And for intentional crimes, it's essentially a single senior officer. There's a little bit of debate about the paragraph 3 of 22.1, but 20.2, but I'm not going to get into that. So you need to find an individual.
So it really does protect the corporation.
Well, it makes the prosecution's job harder unless you've got an admission, which doesn't happen that often.
A lot of the interest in incidents, and that brings issues of regulatory capture to the public's attention, result from really big, devastating disasters that come to public attention, whether they be extreme like Chernobyl or Fukushima, or even smaller but horrible crashes of jumbo jets, or tragedies like the Ocean Ranger, or even the devastation you were talking about earlier, Bruce, at Lac Megadict by a runaway train. All these are rare occurrences, but they happen. How do we ensure, what can be done to ensure that corporations undertake the often substantial expense that would be necessary to prevent these rare but devastating occurrences, rather than simply not taking the precautions and saying, well, if they happen, we'll deal with them as part of our ongoing business plan. It's cheaper to do it that way than to make the investments to help ensure they don't happen. Is this something, for example, you've run across in the nuclear industry, Theresa? How does the industry respond to this issue?
Yeah, absolutely. Well, in fact, it's built into the international and national approach to nuclear operation and nuclear decision making, as well as licensing and regulation. And it's a principle they articulate called as low as reasonably achievable social and economic factors considered. And so in essence, what happens is the industry makes an argument to the regulator to say that something isn't reasonable to do because the cost would be excessive for the quote benefit. Now, there are additional principles that are supposed to be utilized, like not exposing people to new sources of radiation unless they or society at large are gaining a benefit, and those are not well applied in the Canadian context. But this approach then sees its way in this it's called a science, but it's really an art of risk assessment and probability assessment. And these tools were developed for the nuclear industry and for the pesticide industry, among others, both of which share the hallmark of coming out of World War II technologies. In the original development of the nuclear industry, this concept of worrying about the very, very huge consequences compared to benefit to society as a whole was sidelined, of course, in a military context. And then it took a long, long, long time, and we still are not really past the point where that military outlook colors the whole approach to regulation of this industry. You mentioned a moment ago about secrecy. So that's a perfect example where secrecy was obviously completely included in the whole approach to nuclear development. And then even once it became a policy objective to pursue nuclear power and civilian use of atomic energy, there were many aspects that were still shrouded in secrecy and continue to be, not the least of which is terrorism or diversion to non-state actors for misuse. A lot of the materials and equipment, would have those uses, and Canadian technology actually is directly responsible for a lot of expansion of nuclear weapons in the world, which we don't like to admit in Canada because we think we're on the side of right in this area. But it comes up in the regulatory context because then civil society, communities want to ask questions about how well the materials are safeguarded, how well things are protected, whether they could be diverted during transportation. And all of that goes into non-public hearings with no documentary disclosure or public participation. And then similarly, in terms of current debates, and something I discuss in the chapter in the book is the promotion of the industry by the regulator instead of the regulator limiting itself to the safety job, which again comes out of this origin in World War II development of the technology, and the fact that there was little separation of the objectives, and that's continued to this day with no separation of the oversight by separate ministers, which I call for in the book and point out that many committees and standing committees and Royal Societies have called for the same thing over the years, and it just hasn't been implemented. So that's kind of how this issue of probability assessment, risk assessment, it gets conducted, but then it gets to be very, very difficult for the public to access this information. Even something like looking at whether or not all of the potential reasons you might have a nuclear accident are considered. Well, many of those were never considered because they were considered so improbable. We found out a few years ago that some of the extreme events like tornadoes were not properly considered in the assessments, and the regulations have not made up for that yet. And then on top of that, you have this secrecy that developed in a different context and continues to apply kind of across the whole sector, albeit there are nods to transparency, but on the whole, it's pretty secretive. And then these cost-benefit decisions are very, very non-transparent to the public.
Bruce, the transportation industry, whether it be air or rail or marine, the potential for disastrous accidents through corporate misbehavior or not taking safety practices and so on is presumably something that regulators are to look out for. But is there the same difficulty in the regulators getting the industry to take the appropriate measures to prevent these rare but devastating problems?
Yeah, yes. And I've looked at a number of major disasters besides Lac Megadict, the Ocean Ranger oil rig that sank off the coast of Newfoundland, the 737 MAX 8. And so I looked at a number of them, and a number of disasters are mentioned by various authors, including in the pharmaceutical sector and the drug sector, and the result of risk assessment not being properly leading to the approval of pharmaceuticals which are unsafe and have resulted in deaths. But so in terms of the lessons that I've come to from examining these, and others can intervene, but basically the lessons learned by governments are that they start off by make a big deal. We're going to look for the cause. We're going to hold those responsible to account, and we're going to take the measures to prevent their recurrence. And so what happens after the passage of time, people tend to forget public consciousness of what happened. I mean, you talk to especially younger people about Lac Megadict, for example, and the memories have really faded, and so government commitment just kind of wanes. And on the corporation side, well, as was mentioned, the probability is low. The cost of implementing effective safety measures is high, and as Jennifer pointed out, the cost of potential lawsuits is manageable. In other words, it's business as usual. And so then it happens again.
Jason, are there equivalents in the environmental sector in which you work or your colleagues work?
There are both specifically, and generally. Specifically, I'm thinking about the recent decision of the Federal Court of Appeal with respect to the Pest Management Regulatory Agency in Canada, which was making decisions, and it made a decision in 2017 at the behest of Monsanto to increase the levels of formulated glyphosate, which has been found by international agencies and independent scientists to be a likely carcinogen. Monsanto asked PIMRA, or the Pest Management Regulatory Agency, I call it PIMRA, to raise the acceptable levels of glyphosate for pre-harvest use in Canada, meaning the residual effect of this likely carcinogen in the Canadian food supply. Now, the cost concentrations that Monsanto face are enormous. If its registration of that product were to be suspended, as it has been, it turns out, but for other reasons, because it just became a scandal, the folks at PIMRA went ahead and did Monsanto's bidding without even checking with the Minister of Health and the other ministers who exercise oversight. Now, what has the government done? I mean, this is getting to the answer to your question, Jim. And I'm a little bit more pessimistic in terms of, readily available response options. Well, the government of Canada has announced $42 million as part of a transformation agenda, that's what it's called, for the agency. But that figure is nowhere near enough to give the agency the capacity that it will need to exercise its own scientific competence and assessment and keep up with the scientific literature. So the reason why the United States EPA, the European Food Safety Authority, and the Pest Management Regulatory Agency in Canada essentially are telling the public, hey, it's okay to use this product, it's unlikely to cause cancer, is because it doesn't have enough money to actually do the tests that are required. So it relies instead on Monsanto's own supplied tests and tests from the industry. So one automatic lesson that you might readily take from that, and I guess this is sort of regulatory capture 101, is that we have to restore and really enhance the administrative budgets of our regulatory agencies. But that in and of itself raises a more fundamental question, which is that's a really obvious lesson that we continue not to implement. Regulatory capture goes beyond the pathologies of slashed budgets and asymmetric information advantages, and it goes to the very culture. So we don't have an independent assessment regulatory culture in Canada. And I mean, to go back to, Jennifer's amazing case study, I mean, I remember being glued to my computer screen, watching SNC-Lavalin and just being amazed that our, elected representatives were falling all over themselves to protect this particular company, at the great detriment of those members of cabinet who exercised independent integrity, who are no longer part of the government. And until we really root out that level of ideological rot in our country, that companies know best, and big industry, after all, is the source of innovation and economic growth, and the government is really just meant to facilitate it. We have to really fundamentally change some of our cultural notions before we'll be able to ever be in a position to implement some of the practical solutions to regulatory capture, like funding and expertise.
Thank you so much, Jason. Actually, you anticipated where I was going to go with my final question. We're getting to the point where we really need to turn to the audience for their questions, which I will do in just a minute. But before doing so, I want to say I'd like to come back after we deal with a few questions to the rest of the panelists to pick up on the issues Jason was just raising about how we can make regulation more effective and
Can I jump in, Jim, just before you go to the question, because I was actually going to answer some of the questions.
Okay.
But also I think, practically speaking, I think there's some hard truths that people, so it's easy, and I say that as someone who's very critical of corporate behavior and has spent my career looking at ways to hold collective entities to account, because that's where a lot of power is wielded. But we also have to hold the mirror up, and I think that one of the hard conversations about regulatory capture is it tells something about us as well and what's important. And I think that Jason is absolutely right that why would we impose on corporations the obligation to, for example, to do this preventative work or this upkeep work? Well, I can think of a few. The first being that, as was the case in Lac Megadict, there may not be anything left when the bad thing happens. So, and I'm pretty sure that Jason might have some things to say about the orphan wells, in the that are in the oil patches. So it's all fine and dandy, let's put off the expenses because it won't be our problem. We'll make sure the assets are gone, and it'll essentially become a state responsibility. And maybe that is unavoidable, but if that's the case, then we need to front load some of the responsibility and the costs, and maybe change our bankruptcy laws, for example, some other things that are there. But the part of, I think, the difficulty is that there is not enough transparency about what's going on, what matters to us, and we have to accept that you cannot eliminate risk, and that at some point eliminating or getting closer to elimination costs a lot. Does that matter enough to us as a society? We have to ask those questions. We do not have infinite resources. So these questions are hard. They are not simple, and they do require choices. And these choices will almost inevitably cost lives and resources and other things. And we have to be able to look ourselves in the mirror with that. It's really important to remember. But I do think in order to have those frank and hard conversations, we need information. And that's the other thing that Jason mentioned, expertise. And I'm going to do a tiny segue to the digital economy, and then you can go back to the questions. What is happening right now in the governance fight over the digital economy is not unlike what has happened in these other areas, is that there is a fear, and it is, nicely, fanned by those who are interested in maintaining that fear, that government is incapable or unable to understand the complexity. And my goodness, if you interfere, you're just going to ruin it all. And there's this notion that innovation somehow has to happen in a government-free environment. That's factually untrue. The connections between research, I'm at a academic institution, I can tell you the connections between research institutions and industry is, this murky, and government funds a lot of research that's later commercialized. So this idea that, we have to leave this pristine commercial environment to develop the things we need to grow and so on is fanned by this idea that it's just too hard to understand. And we know how it works, and let us tell you, and we know how best to regulate what we're doing. And that is, frankly, we just have to call that what it is and push back. I'm not going to say it on live event, but I mean, it is at some point, we have to have the resources to be able to have the independent expertise that is not captured in advance. And then the process starts from a different position. And then my final, and then I'll stop. I do want to answer Ken's question at some point, but hi, Ken. It is the other thing we need to remember is that in order to do this process well, we need to expand the voices of people who are being listened to. In the digital debate, this is extremely important, but it's important in everything. We have traditionally over-listened to some constituencies and not listened or under-listened to others. And I think particularly civil society, which can be quite a collection of angles on things, right, hasn't been listened to enough. So those are some of the solutions, but I think we cannot avoid the hard choices. We can simply be aware that we're making them and try to put together the best case for why we make the choices we do.
Thank you very much, Jennifer. That was really helpful. Ange, I think we should turn to the audience now. Could you share the first question that you have?
Yeah, the first question from an attendee, they say regulations only work if they are enforced. This often depends on people willing to put the public safety ahead of their personal self-interest. Yet whistleblowers suffer a sad history of retaliation and isolation. Would you like to comment on this?
Is there anyone who'd like to comment?
I could say something quick. The fact is, socially, as a society, there's tons of academic research to support this. We don't like people who rat out. So culturally, whistleblowers, no matter how noble it is what they do, at the end of the day, people don't like those who've been disloyal, however you want to find it. So I think that the fact is there's a starting problem with whistleblowers that we tend to not like them, even if we may appreciate what they've done. The second thing is we have zero protection for whistleblowers in Canada of any seriousness, that is to say. So I wouldn't want to be a whistleblower in Canada.
As I mentioned, one of the major areas in which the Center for Free Expression works is in whistleblower protection. The International Bar Association and the Government Accountability Project, the largest whistleblower organization in the world, recently completed a study looking at federal whistleblower laws in about 40 countries. And Canada's federal whistleblower law, which was brought in by the Harper government in 2006, was rated the worst whistleblower protection law in Canada. And it's not only the wording of the law, but how it actually has been implemented. We're actually tied with Lebanon for having the worst. There is no, Jennifer is absolutely right, there is no effective protection for whistleblowers in the public sector anywhere in Canada, and there is no protection whatsoever, legislative protection whatsoever for those in the private sector. It's a huge problem if you value transparency. And we're going to come back to that issue of transparency, but in essence, regulation ensures that corporate behavior is consistent with the public interest is at the end of the day dependent on public knowing things and there being transparency. And we have huge challenges in getting governments to help protect that. Government access to information and whistleblower protection when they're in opposition, but when they come to power, they often think, well, maybe secrecy isn't such a bad idea. Bruce?
Yeah, I know. I was just gonna add. I mean, we probably rank about the same place. We used to be, I think, more when they access, you know more about this than I, but when access to information came in, it was seen as pretty, pioneering, but we're way behind the curve now on access to information. And the other thing is companies are able to hide a lot of their interactions with government under commercial confidentiality. And that's another kind of area that needs to be kind of opened up to provide access to the public as well about about their practices and about their interactions with government enablers.
Thank you, Bruce. Could we go to the next question, Ange?
Yeah, the next question is from Kenneth. Kenneth asks, says the West Ray Bill C-45 put responsibility on senior officers to supervise lower level employees, both with respect to intentional and negligence crimes. In my view, the real problem is the low level of resources devoted to law enforcement to investigate corporate crimes. Why, in the view of the panel, do Canadians not seem to care enough to make this an election issue?
Well, I have some things to say. I agree, Ken, that, yes, there is provision for splitting, the material part of the offense. So who actually does the thing, who actually hands the money over or whatever, that can be a lower level employee. And then it's a question of supervision. I still think the evidence issues are hard, and we don't have a lot of examples of litigated prosecutions that actually went to trial where the Crown was successful. We mostly have plea deals, but I acknowledge that. I do think there's a resource problem, and that sort of comes to the second question too, is that, and we have talked about that. I know Ken from the Transparency International Legal Committee, and just chatting about these issues, that I think that there is a resource problem, and part of the resource problem, as many of us have discussed, is that if you don't invest the career path that these people who are going to investigate or commit their time, if you don't ensure that there's a career path and that there are incentives in place for people who commit to getting the expertise, then you will end up with a revolving door problem within the government. And this is exacerbated by funding uncertainty and shifting priorities for enforcement, and routinely, and I think certainly Ken knows this as well, that routinely the RCMP sections devoted to corruption are cannibalized for other things, or the good investigators who want to get promoted have to switch to something else, and so it's not valued. I don't know how we get Canadians to care about it, except to talk about it more, and maybe to really open up the door on what are the consequences of corruption, and that this isn't just a faraway problem. This is a real problem. In fact, there's been more activity on corruption prosecutions with local corruption than there has been with foreign corruption. That doesn't mean, that's probably because we don't know enough, but I agree, resources is a huge problem. I will note that in the budget, the current government has this idea of creating a financial crimes agency, and all of us in the field are cringing at this thought, because we know how messy and complicated it is already, because criminal enforcement is divided between the provinces and the federal prosecutors. So there's a division of labor between police and prosecutors, depending on whether it's criminal code or other offenses. I won't get into the details, but that means it's a very complex space, especially in corruption. And the idea you're going to create another agency with an ambiguous mandate and an ambiguous ambit, and that's going to magically solve anything. No. So, there's a worry that there is a search for a band-aid, a magical solution. There's no magical solutions. People got to do the hard work of cooperating and caring about these things, and that it doesn't win you elections, I think. It's sad to say.
So if I can jump in for another angle on enforcement, in the Walkerton inquiry, you might remember that one of the chapters that Justice O'Connor wrote was on the topic of voluntary compliance, and there had been a change in prosecution instructions and enforcement instructions within Ontario's Ministry of the Environment before that, as part of the general cutting of resources to the ministry and others, and red tape reduction. And so it was an explicit policy that if there were non-compliance events, a path of voluntary compliance would be pursued. So there were some changes made to that in terms of drinking water regulation in Ontario subsequently. But this comes up again in the nuclear sector, and here it's described as dialogue. So if the inspectors are finding some issues in the nuclear power plants or other sectors they regulate, they conduct a dialogue with the license holder to see if that issue can be resolved. And it's very, very, very rare to see compliance action, enforcement compliance action, happen in that regulator. And partly it's driven by the fact that it would be extremely difficult to get convictions because, as I mentioned, the regulatory context is so incredibly vague, incredibly vague. You know, we looked at this, and I described this in the chapter in the book, in the context of one of the licensing hearings a number of years ago for the Bruce plant, and we specifically dived in and looked at the wording in the regulations and in the regulatory policy guidance and the standards that are referred to that the industry has to meet, which are Canadian Standards Association, CSA standards. And, you know, as some of you on the panel with me are lawyers and others in the audience, it says things like, shall have a plan, shall make efforts, you know, shall do their best. You could never get, you know, any kind of conviction with those kinds of so-called standards. And so that's another aspect of regulatory capture that I observe is that, first of all, it's very hard for civil society to participate in this kind of standard setting and affect these regulations. There are these weird rules that go on about how to get copies of the CSA standards in the first place, and I mentioned that I think it's contrary to Treasury Board guidance, in fact, to do it this way. And then it's completely dominated by industry players, both domestically and internationally. And then when the regulator, to its credit, does try to put something more substantial forward, the industry, you know, piles on and from every direction, you know, talks about how costly this will be. And then if you compare an earlier version of that regulation to a later version, you see, you know, words like shall were removed and other places where it was just made very, very weak and vague and non-binding in any sense of the word. So this is another, I think, important piece to think about in terms of compliance and enforcement and regulatory standard setting.
You can imagine if we changed all the traffic laws in Ontario to say, instead of 40 kilometers an hour or 60, drivers shall drive as responsibly as possible.
That's about the size of it, absolutely.
Okay.
Well, there are some generic catch-alls, you know, like that you've driven without regard for the safety of others, but there's more precise ones
I think
that
so.
you can get nailed on. And you do.
We've got a number of questions. Let me try to speed through a few more. Would you share a next one, please?
Yeah, the next one is from Jamie, and Jamie says, at Mining Watch, we have presented a number of corruption cases to the RCMP, none of which were prosecuted, but also only one was even investigated. At the same time, we have laws that are essentially unenforceable due to the absence of inspectors, as much as the political determination to ask nicely for compliance rather than prosecute. In other cases, regulators are reliant on mining companies for transportation and hospitality at remote sites. How independent are they able to be? And where does capture end and deregulation begin?
I think that may be a rhetorical question, and Jamie may have answered his question in the asking of it.
Yeah.
Bruce, do you have any comment on that?
I agree. I mean, I've seen it in the sector, in the transportation sectors where I've investigated carefully, but you know, most of the public, when you do public, when the public is, what's the word I'm looking for? When the public is asked to comment on, for example, do you trust corporations to regulate in the name polling? Thank you. In the name of safety, and they don't trust corporations to regulate, and so they do at some level believe that safety should be the #1 priority, and that there shouldn't be this kind of self-regulation kind of ethos that's developed in so many sectors. And maybe this book will help to raise awareness of all of the, you know, the flaws and the problems that exist. And just, you know, for one more example, we have a regulatory policy that was initiated by the Harper government, and its central premise was the 1-for-1 rule, so that every every regulation that is proposed, you have to withdraw a regulation. And so this can lead to all kinds of,
It's just
Hobson's choice type.
terrible. Can I just say that?
And they also replace precautionary principle with risk assessment, and others have talked about risk assessments. And that policy has only been changed marginally by the Trudeau government, since it came to power in 2015. And so, and there's something called the Red Tape Reduction Act, which is talk about a loaded term. There's that legislative change and raising awareness of that. But I think, ultimately it's going to be a question of labor groups, farm groups, environmental groups, public interest groups, just pushing and pushing and pushing. And I know, it's difficult because of the access to information, because of the access to all of that is difficult, but that is going to be the way that the path forward. Sorry.
Jason, I want to ask you a question. You can add what you want. Bruce made reference to precautionary principle as opposed to risk assessment. Could you just clarify for the audience what the difference is and why it would matter?
Oh gosh, we don't really have that much time because there's so many different versions of the precautionary principle, but the strong version of the precautionary principle, the only one that makes sense, means is that you shouldn't use the presence of scientific uncertainty as a basis of not taking preventative measures. So for example, if you were to say to a corporation, maybe you shouldn't drill that mine, that could be unsafe. The mining company will say, oh, prove it. It's uncertain. And so the strong version of the precautionary principle would reverse that burden and say to the proponent of a potentially dangerous activity, no, you prove it's safe. Yeah. But we have mention of that in our environmental laws, but it's honored more in the breach than it is in observance. The point I just wanted to say, to echo Jennifer's earlier point, which I think is so important about the hard truths and regulatory capture being a bit of a mirror. I agree with you, Bruce, about your point that Canadians are awry enough people that we don't just blindly trust corporations. But here's where the Canadian public, and not just civil society and interest groups who are too easily written off as being biased because they have a particular interest, but Canadians too often buy into industry rhetoric and discursive strategies of saying regulations cost jobs, and they continually put up this false dichotomy. We have to continue to drill for oil off of Newfoundland because Newfoundlanders need jobs, and there's only one kind of jobs that they can have, and they're oil jobs, and there's no other kind of jobs that we can presently imagine. And so Canadians need to get they need to become more engaged and more critical of those easy dichotomies. If you regulate us, we'll leave. I mean, oil drillers can't just leave the oil sands and take the oil sands with it, right? But in Canada, we've let corporations scare us away from strong regulatory measures by talking about jobs. And so our economic insecurity and precarity, which is only getting worse due to a number of other factors that we've only we haven't even had a chance to scratch the surface of, is going to be another thing that we'll have to factor into the solutions to regulatory capture.
Okay, Ange, another question?
Yeah, the next question is from John. John says the UK has done an excellent job in exposing the sordid story leading to the Grenfell Tower fire. Canada does not seem to do the same. Would anybody like to comment on this?
Well, I think there are differing views on how well that inquiry into the Grenfell Towers is going, is the first thing. I think that this touches on something that everyone has mentioned, which is that transparency is the first step. You need to have mechanisms that allow you to understand what happened and to have a full airing of those things. And I think that's why so many people wanted a public inquiry, for example, into the Lac Megadict derailment, because, I think people understood there wasn't going to be liability attributed and so on, but, just getting to the facts and getting to the facts in an unvarnished way, where you hear all the voices and then you know, someone sorts through it or a panel sorts through it. You know, it's not perfect, but it's a lot better. So it's mechanisms for accountability start with transparency. That's not the end of the story, but and I think one has to be realistic about, you know, the capacity for accountability, unfortunately, because there is this great reticence. I have to echo what Jason said, the scaremongering. I'm always surprised that people are very distrustful of government, very quick to, you know, but corporate claims are equally, you know, open to criticism. And I think one of the things that was astounding, and then I'll stop, I know I've talked too much, in SNC-Lavalin, you had all these politicians defending, you know, saying we need a DPA because my goodness, all these jobs are going to disappear. It was actually factually incorrect.
Yep.
But the company was happy to let them just do their job for them. The company didn't lobby for that, right? It was the government lobbying against what is supposed to be an independent prosecution service. I mean, as it turned out, the prosecution service had a little more spine, and wasn't swayed by that. I think you can have a different debate about whether in other circumstances you might consider a resolution that also takes into account other factors. But I think it's the unwillingness to really critically challenge. And I like this idea that maybe the uncertainty of the future, which we will never get away from, might need to be resolved in favor of the public interest position rather than the corporate position. That would be a huge step, just that.
Okay. Ange, next question.
Yeah, the next one is from Jamie. Jamie asks, at what point does capture become institutional corruption, if not actual retail corruption?
Who would like to respond to that?
I'm
I
going
think
to
that's-
I'm going to take it with a slightly different angle because in the chapter I wrote for this book, it's very much about independence of the regulatory institution is the framework that I put on it. And so yes, I hear you. I'm not going to say that, you know, I'm not going to label it as corruption per se, but the outcome is perhaps the same, where you have the inadequate separation of the ministerial oversight and the very close identification between the industry and the members of government and the regulator all in a trilogy. And so they all come to a common view of the best outcome and often are leaving the public interest, especially in a context like nuclear power, where the public around the plant or in the path of a weather event may be the ones who would bear the risk or the consequences of an accident. And so that blurring, that institutional blurring and that failure to appreciate the very, very distinct role as a regulator versus a promoter of the industry is really a huge problem in the nuclear sector. And that's how we're getting, you know, this SMR roadmap, for example, as an alleged answer to climate change, which is just not the case, diverting resources and distracting from proper, you know, renewable and other conservation, other answers. And this, you know, repeated failure after you've had so many standing committees and royal commissions and recommendations of advisory committees talking about that being a first step in unpacking that meshed institutional context, you know, fail to come to be. And it's because that is so enmeshed right into the bureaucracy that advises the government on how they should institutionally set up the oversight. And, you know, despite Fukushima saying, the Diet of Japan saying, you know, it got temporarily separated in terms of ministerial oversight and then it had been put back together, unfortunately, just before the accident. That in itself still wasn't a wake-up call for Canada, despite having this Fukushima action plan here in Canada. So that's the kind of thing that I think the public can constructively say is we don't want the same people making decisions about safety as are making decisions about promotion of whatever industry it is. And that's very true with the ministry or the department rather that regulates nuclear power, which happens to be the same one that regulates and promotes oil and gas in Canada.
Well, it's the same in agriculture too, doesn't the Department of Agriculture both promote agriculture and regulate? Bruce, you were wanting to.
No, it's all right. I was no, that's
Okay.
fine.
Okay.
Could I just say,
and-
James, one thing that, Jim?
Okay, quickly, because I want to get to one question.
It's you have to remember that this highlights this, you know, the possible influence, the relational nature of regulation. You know, regulation is not a discrete event. It occurs over, you know, years, and so people develop working relationships in part because that kind of has to be how it is. So if we forget about the fact that it's relational, then you will try to apply solutions that don't work. So we cannot just pretend that people can't get along or people can't know each other. You have to develop solutions that acknowledge the relationship that goes on there.
Very good point.
Yeah.
Andrew, I think we have time for one more question.
Okay, the next question is from Bill, and Bill asks, says, I'm interested in ideas for solutions and theories on why there is sometimes or often no media coverage. Can the panelists comment on this?
Yes.
Jason.
The media, I'm so glad that that question came up, and sorry to jump in. I'll keep this brief.
Oh, it's your
Go ahead.
Go.
Our, you know, our corporate media is among the most highest, has the highest concentration of corporate ownership in the world. And so the media, you know, whether it's television or whether it's the Globe and Mail through the newspaper, et cetera, established media channels are themselves part and parcel of the same elite industry influences and messages. And so when you look at, and the great work of the Corporate Mapping Project has done this, and other scholars have looked at it as well, you have interlocking memberships of boards of directors in the financial sector, in the energy sector, in the big agriculture sector, and the media, right? So we don't actually have a very effective media in Canada. Now, we have really good independent media, a lot of really fantastic independent investigative media, but unfortunately, they don't have the resources to reach the audience. And so again, this is one of these hard mirrors that we have to hold up to ourselves. This is only going to get better if Canadians begin to demand better reporting and better investigative reporting and more critical reporting. So the way things stand right now is the media is a big source of the problem. I've written a whole other separate article about how the Globe and Mail has served for decades as a cheerleader for the oil and gas industry and continues to promote oil and gas as part of our climate change strategy, which is astonishing. But it's not astonishing when you trace the interests of the Thompson family that owns the Globe and Mail and its interlocking interests with the financial sector and the energy sector. And when you map all of that out, it looks really quite obvious.
Bruce, you had started to.
No, I was just going to say, Jason, that's a perfect question for Jason. I just support. I guess I you know, when you're looking at the question of how to break the stranglehold, the corporate complicity stranglehold, that whether it's in the media or the financial sector or regulatory capture, I think the need to break it. I mean, I think of the moment we're in. I think of the existential crisis that we're facing, and if we and you know, Jason might want to comment on the RBC report that just came out saying, no problem, you know, we can go on producing. By the way, Ukraine needs the resources and you know, and so forth. But you know, just it seems like this particular moment, this climate crisis moment, is, you know, the need to break that stranglehold has never been greater. And so, you know, if we can, you know, if we can tie those two together, and I would include the inequality, the pyramidal dimension, the fact that, you know, we talked about, well, we haven't mentioned the word plutocracy, but it's those who are at the top of the wealth and power pyramid. And if we can't address that and confront that, then I think we're in real big trouble in Canada, not only in Canada, but in the world.
I'm afraid I'm
On that happy note,
Elon Musk.
I was going to say, who's going to talk about Twitter?
We're coming to the end, so I'm glad we have such a lively panel and we've had such good questions. I'm sure we could go on for a very long time. And the question that I had wanted to ask before we turned to the audience and said we'd come back to, we don't need to come back to because you provided wonderful answers to it, was how do we make regulation more effective, insulated from capture? I've got so many notes here, I feel like I could write a chapter for the book just on that question, thanks to your contributions. I really do want to thank the panel. Jennifer, you did make one observation that I do want to comment on, an observation I absolutely agreed with, but there is a nuance to it, and that is, it would be wonderful if we got to the point where we resolve uncertainty in the public interest rather than in the corporate interest. I think the big challenge, I couldn't agree more, the big challenge is the ability of those to convince people that the public interest is the corporate interest. I think that's the biggest challenge. In any case, you guys have been wonderful. I really thank you for a lively, terribly exciting and informative discussion. And Randall, I don't know if you can do it again. If you could put up the image of the book. This is a wonderful book that really provides insight into regulation and issues in a number of different industries. It's just been published. Randall, are you able to put up the cover of it? We'll see in a second whether he is or not. If not, oh, here it comes. So that the book, Corporate Rules, The Real World of Business Regulation in Canada, is published by James Lorimer and Company and should be available in any independent bookstore, or if those of you who want to rely on Amazon will do so. I'd encourage you to get it. Again, thank you to the panel and thank you to the audience. Now, the next event in our series will be in our events at the Center for Free Expression will be a week tomorrow on Thursday, May 5th. And it'll be one of the most exciting panels that the center has ever put on. Our guests, the title of the panel discussion is Putin's War on Journalists. And the guests on the panel are three of the most important Russian journalists. One who is the news director and anchor of Rain TV, which was Russia's last independent TV channel that was closed on March 3rd, 2023. Another is one of the most prominent investigative journalists, reporters and editors with Meduza, which is, I think, the most important independent Russian news site. And the third, who was the editorial page editor of Vedomosti and is now an opinion writer with the International New York Times and the Russian blog file writer for the Keenan Institute. And they're being joined by Chris Brown, who was a longtime CBC foreign correspondent in Moscow and is now reporting from Ukraine. So it's going to be a really exciting and informative discussion. These four have never been able to be brought together, although each has been independently on CNN or other places. So this will be next Thursday, May 5th at noon. We're doing it at noon because they're in different parts of the world, and for time zone reasons, noon is when we're going, noon Eastern time. So I'd encourage you to look in. You can check out the details on the Center for Free Expression website, which is cfe.ryerson.ca. Also, the video of today's conversation is going to be posted on our website tomorrow, and I'm going to be asking the panelists and the debrief we're going to have afterwards to suggest some resources. So along with the video, we'll post some suggestion for links that those of you who'd like to read more or see more, or learn more about the topic of today's panel can find interesting and informative reading. So thank you again so much.
Can I just make a quick interjection, Jim?
You may indeed.
Just to say that there's another book event for this book that's happening, that's sponsored by York University Faculty of Environmental and Urban Change on May 11th. Just wanted to let people know to take a look at that.
The York University
Faculty of Environmental and Urban Change. It used
so
to be
Google
Environmental Studies.
Website, you could get the details.
Yes, you can.
Okay, thank you to the audience, and especially thank you to the panel for a wonderful discussion. Goodbye, everyone.
Bye-bye.